All right, so if you're gearing up for the Queensland bar exam, I'm guessing you're probably neck deep in the Evidence Act right now, just memorizing sections, exceptions, the whole deal. But here's the thing. To really get it, to actually master it, you've got to understand why these rules even exist. So we're going to take a little trip back in time, from a courtroom that was pure chaos to the structured code you're staring at today. Trust me, knowing the story behind the rule, that's your key to actually using it when the pressure's on.
So here's the plan. First, we'll look at what courts were like with basically no rules. Then we'll see how the jury itself actually gave birth to the hearsay rule. After that, we'll focus in on Queensland's own journey, break down the big one, the Evidence Act 1977, and finally, we'll tie it all together and show you why this history is seriously your secret weapon for the exam.
Okay, let's kick things off. I want you to picture a place that would feel, well, completely alien to any of us today. Imagine a courtroom with almost none of the rules of evidence we take for granted.
And get this. This quote, it isn't a joke. It's from a real case back in 1621. You had one guy who was supposedly a witness, and another guy was considered just as credible simply because his dad told him so. That's it. My father said so. That secondhand statement, pure, unadulterated hearsay, was accepted as totally valid proof. Can you even imagine trying to run that in court today? No way.
And believe me, this wasn't just a one-off thing. You know, there's another great example from 1669, the case of Reverend Hawkins. He's accused of stealing a pair of boots. And the Crown's evidence? They called witnesses to get up and swear that they heard another guy say that Hawkins did it. It was just a total free-for-all. Rumor, gossip, what someone's dad said. That could be enough to get you convicted. Verifiable facts be damned.
So the big question is, how on earth did we go from that chaos to the super strict, exclusionary rules you're poring over for your exam? Well, the answer is kind of surprising. It's all about the jury.
Right. We all know the definition, don't we? It's the classic rule you have to recite in your sleep. It's all about stopping those out-of-court statements from being used to prove the truth of whatever they're asserting. Simple enough. But the reason for that rule? Now that is where this story gets really interesting.
And here it is, the key takeaway. The hearsay rule wasn't dreamed up in some lofty philosophical debate about the nature of truth. Not at all. It came from something way more practical. And frankly, a pretty pessimistic view that 19th century lawyers had about juries. They just didn't trust them. They were convinced that regular people, jurors, couldn't figure out how unreliable secondhand info was, that they'd be too easily swayed by it. So the rule was literally created to protect the jury from its own perceived flaws.
All right, so let's bring this story home, to our own backyard. Because while all these ideas were bubbling up in England, Queensland wasn't just sitting around and waiting. Nope, it was busy forging its own legislative path, and sometimes it was even leading the charge.
So check out this timeline of the key steps. We start in 1867, with Queensland basically adopting the latest English reforms. But then, look at 1892. This is huge. Queensland made it so an accused person could actually testify in their own defense, and they did it a full 6 years before England got around to it. That was a really progressive move, you know? It showed the local lawmakers were really thinking for themselves. And that independent streak just keeps going right up to the modern act and all the big changes we've seen since. But of course, making these big changes was never easy. And this quote, it just nails why. James Fitzjames Stevens said that trying to codify evidence law is like trying to get a committee of the whole house to paint a picture. I mean, can you just imagine the chaos? It perfectly captures how hard it is to get a bunch of lawyers and politicians to agree on one single coherent vision. It's messy, and that's exactly why an early attempt to create a full evidence code right here in Queensland back in 1874 just fizzled out. The painting was just too complicated for the committee to finish. Which finally brings us to the main event, the absolute centerpiece of your studies, the Evidence Act of 1977. This is it. This is the culmination of literally centuries of common law and all those decades of local Aussie legislative tinkering. Okay, now listen up, because if you only remember one thing about the Act for your exam, make it this. It is not a complete code. I'll say it again. It's not a complete code. The Law Reform Commission that put it together was super clear about this. They weren't throwing out the common law. They were just trying to modernize it, to clarify bits and pieces. This means, and this is crucial, that in a lot of places, the Act only really makes sense when you read it with that common law history we've been talking about.
And the 1977 Act really did bring the law into the modern era. It brought in new rules for things like children's evidence, it tackled the issue of business accounts, and it even tried to get its head around the, at the time, brand new challenge of computer-generated info. And, of course, it made that huge change with Section 101, allowing prior statements to be used as actual proof of the facts. That's a massive shift, and one you absolutely need to have down cold for the exam.
Okay, so we've gone through a lot of history here, right? And you might be thinking, that's interesting, but how is knowing about some wacky 17th century trial going to help me in a high-pressure exam room? Fair question. Let's connect the dots right now.
And this right here, this is the result of that whole journey. It's the before and after. On one side, you've got the chaos, evidence from literally anywhere, convictions based on rumors. And on the other side, you have the code that you're studying, a set of strict rules designed for one purpose: to filter out exactly that kind of unreliable, prejudicial stuff. Every single rule, every exception you're memorizing, it's there to stop the chaos on the left from ever happening again.
And this really is what it all comes down to. When you're in that exam and you're staring down a really tricky hearsay problem, don't just scramble to remember a section number. Stop and ask yourself, why does this rule exist? What was it designed to prevent? And the answer is, it was designed to stop unreliable evidence from getting to a jury that lawyers feared might misuse it. Once you get that fundamental principle, that why, it's like a key. It unlocks the logic behind all those complex exceptions and lets you build an argument with real confidence.
So I'll leave you with one final thought to chew on. The law is never static, right? We're seeing more and more statutory exceptions like Section 93B that kind of chip away at that original strict rule. And it really makes you wonder, are we slowly moving toward a future where we trust judges and juries more? A future where we let more in and just trust them to figure it out? Or is that foundational, deeply pessimistic view of the jury still a safeguard we absolutely need? Something to think about. Good luck with your studies.